Good evening, Arlington Young Democrats. Thank you for staying tonight for our third and final debate. I would also like to thank both of our candidates. I will say I am personally very proud and glad to have two strong and accomplished women having a philosophical debate about what the role of the Commonwealth's attorney is, and to help all of our members understand a bit more about the role of the office, as well as what you as a candidate would bring to the office, so that they can make an informed decision on June 11th. So just as y'all know the rules by now, but we're going to be 2 minutes opening statement each. Ms. Tafti won the toss, so you're going to start. Are you ready?
Thank you, Arlington Young Dems, for hosting, Maggie for moderating, and everyone for coming out this evening. Our criminal legal system needs real reform. But the questions for this debate and for this election are, what does real reform look like here, and which of us is better suited to deliver it? My experience in criminal justice is deep, broad, and diverse. For the past nearly 20 years as a public defender, an innocence attorney, and law professor, I've worked to identify and fix the mistakes in the criminal justice system. I've practiced at all levels, from trial to Virginia Supreme Court. I investigate decades-old cases of serious crimes, such as arson, rape, murder. I decided to run for Commonwealth's attorney because I noticed that our criminal legal system here in Arlington and the city of Falls Church doesn't reflect our values. Our community is wonderfully diverse, inclusive, tolerant, and forward-thinking. Our schools and our local governments are progressive and a model not just for the Commonwealth, but for the country. But we're lagging behind on criminal justice reform. Why is it that Charlottesville eliminated cash bail nearly 20 years ago, and we haven't? That Prince William County and Norfolk have a mental health court, and we don't? That Fairfax and Alexandria provide electronic discovery, and we don't? That Loudoun has a restorative justice program, and we don't. I'm running because I believe our community can do better. We should be and could be a leader on criminal justice reform, and I believe together we can get there. I look forward to answering your questions and to earning your vote.
Good evening. Experience is a touchstone in leading this office. In 31 years as a prosecutor, I have tried more than 100 jury trials, more than 1,000 bench trials, and I've supervised the prosecution of thousands more. I have never had a conviction overturned on appeal, and there has never been a wrongful conviction in Arlington County in the past 3 decades. Whether it was creating Arlington's first drug court, supporting the creation of our Second Chance program for our youth, or expanding criminal discovery in our office, to lobbying to increase the felony larceny threshold in Richmond, which we succeeded in doing, I have been a leader. Arlington is a public safety success story, and it's because of programs and initiatives that I have led on. Just recently, we collaborated with the Police Department, Sheriff Arthur, and the Department of Human Services in introducing an innovative program called Operation Safe Station. It gives individuals the opportunity to turn in their personal use drugs and avoid arrest and prosecution so long as they agree to seek treatment. That's real diversion. I have been the leader in protecting the rights of LGBT crime victims. Long before the state law required it, my office insisted that cases of LGBT intimate partner violence be heard in the Juvenile Domestic Relations District Court because these relationships deserve equal treatment with other intimate partner relationships in the broader community. It is through my leadership that Arlington has a state-of-the-art protocol dedicated to improving services to victims of sexual assault, which serves as a model for the Commonwealth. I have more than 3 decades of experience promoting progressive values to ensure the fairness that is accorded to defendants while never forgetting that the criminal justice system also exists to provide justice to the victims of crime. I will continue to promote these values if I am fortunate enough to be reelected your Commonwealth's attorney. I'm going to ask for your vote June 11th, and I look forward to tonight's debate. Thank you very much.
And thank you to you both. So from that, since Ms. Tafti began, the first response to the question will be to Ms. Stamos. And this first question, there's two parts to it.
I'm sorry, is it to me?
It's to you first, yes. So it's questions for both candidates, Theo first, and there's two parts to the question. First, is there any public safety reason for a person arrested for purely a drug possession offense to spend any time in jail? If yes, please elaborate. If not, what is the county's role in helping people who are caught with drugs but otherwise have not committed a crime?
Well, so it depends, of course, on the type of drug that we're talking about. Clearly, possession of marijuana should never result in anyone spending any time incarcerated. In fact, in Arlington, that's not what happens. An individual arrested for possession of marijuana is released on the same piece of paper you get for a speeding ticket. It's called a Virginia Uniform Summons. You're not booked, you're not handcuffed, you're not put in a squad car, you're not taken to the sheriff's office to be processed. It depends, of course, on if a person is under the influence of a drug that they have in their possession. They might need to be taken into custody in order for their own safety. So those are some concerns that would enter into that decision. But make no mistake, there is no one sitting in the Arlington County Jail for simple possession of marijuana. That's not occurring. And I'm sorry, the second point of that question?
That you hit both points.
Okay, thank you.
Ms. Tafti?
The answer is that in most cases, I don't think that there is a public safety reason for somebody who's simply in possession and nothing else for them to spend time in jail, because chances are the person needs treatment, and jail does not provide appropriate treatment and has never gotten anybody clean. The point that my opponent made, which is that marijuana is on the same is essentially like a traffic ticket. It is not like a traffic ticket. It may come on a piece of paper like a traffic ticket, but a traffic ticket you can prepay is a civil penalty, and you can prepay it and be done. A marijuana summons requires you to show up in court, or you will actually be tried in absentia. You will receive up to a $2,500 fine, and the only way you're going to avoid jail time in a marijuana possession case in Arlington is to plead guilty. And once you do that a second time and a third time, you do end up in jail.
Thank you. The next question is again for both candidates, starting with Ms. Stamos. Should people in jail and or prison be allowed to vote? Why or why not? And if not, when, if ever, should someone's voting rights be restored?
Well, I certainly support the restoration of rights for convicted felons. And Virginia has a very robust process whereby individuals who have had felony convictions can appeal to the governor to get their rights restored. And I support that effort. I think the determination of whether or not an individual should be able to vote from prison is a determination that needs to be made by the General Assembly. And I also think that the Virginia Constitution would have to be amended in order to allow that to occur.
Well, I don't think that anybody should lose their voting rights because they have a conviction. We know that these laws were created in the Jim Crow era, and they were created in order to keep black people in as close to a state of slavery as possible. Virginia remains an outlier, and it's one of only 2 states that have a automatic loss and where you do not get your rights back automatically. I would support restoring the voting, never losing them, but if anybody loses them, restoring the voting rights automatically, because we know that restoring voting rights actually makes us safer, and because increased voting rights are associated with lower recidivism rates. But I also want to say that my opponent opposed Governor McAuliffe's efforts to restore voting rights, and says that she did it because it would fast-track gun rights. But that's just not true. The truth is that getting gun rights back is a totally separate judicial proceeding.
That is time. And then you would like to use...
Right. I fully supported the governor's goal of restoration of rights. The problem is that the governor abrogated the Virginia Constitution in doing so. Governor Kane had tried to do the same thing, was told by his counsel that it was not a thing that he could do. What the governor did was he fast-tracked the ability of convicted felons to get their gun rights restored. And the fact that there's a separate proceeding does not obviate the need that fast-tracking took place.
That is time. Thank you. So the next question is directed to Ms. Stamos. Ms. Davis, what, if anything, has your office done to reduce the racial Oh. Okay, yes, I've been corrected. So put a pin in that question. We're going to go to a question directed to Ms. Tafti. Ms. Tafti, have you tried any cases in Arlington or Falls Church? And additionally, do you believe extensive local trial experience is important for this role? Why or why not?
I don't think that extensive local trial experience is important to this role. What's important to this role is having hindsight and knowing how the system makes mistakes and how to fix them, and being able to reflect on how the system functions in an honest way. My opponent has insinuated repeatedly that I lack experience, even though she knows I have 20 years of criminal justice practice, and even though she knows that on a daily basis, the cases that I handle are far more complex than the simple marijuana possession cases that she insists on prosecuting. We all know that she's not challenging my experience. She's challenging whether someone like me, who has spent a career defending the poor, exonerating the innocent, and fixing the mistakes of the system, should be making decisions about who and what to prosecute on the front end. But the military requires lawyers to switch sides precisely so that they don't get entrenched. And my answer is that if you want a system that makes us safe, is humane, is transparent, reflective, and based on evidence and data, then you
Ms.
definitely
Tafti,
want
that is
me.
time, but I do want to use moderator's discretion to see your question to the first answer, or answer to the first question. Have you tried cases in Arlington or Falls Church?
No, and I don't think it's necessary to. This is not a trial attorney position. This is a management and policy position.
Thank you. So the next, would you like to use rebuttal?
Use the
All
flag
right.
again. My opponent doesn't think it's important that she ever had a jury trial or a bench trial because, and says that it's a management position, is simply untrue. I go to court every single day, and every single day, the prosecutors in my office look to me to be able to plan trial strategy, to understand how to prepare an opening statement, to introduce critical and complicated evidence. It's important that you have the ability to try cases. My opponent has not done that. I absolutely value the work she's done as an appellate lawyer,
Yes,
but this
that
is
is
a trial
time.
job.
Sorry, that is time. I think there was another.
Yeah, I'd like
Rebuttal.
to rebut,
Yep.
please. I've had a front row seat to the mistakes that prosecutors make that ruin innocent people's lives while allowing perpetrators to walk free. Mistakes that re-traumatize victims and survivors, and mistakes that take decades and multiple hearings to fix. It is exactly that experience that I bring to train prosecutors not to replicate the mistakes of the past.
Okay, thank you. That is time. So going back, we had a bit of a back and forth there, but the next question is directed to Ms. Stamos. What, if anything, has your office done to reduce the racial disparities in the criminal justice system in Arlington and Falls Church?
Well, I obviously this is a topic of discussion in this debate, but it's important for everyone to know that we never consider the race of an individual who we're prosecuting. That is just simply not a feature of the job that we have. When an assistant comes into my office to ask about a disposition and a plea offer, I want to know the facts of the case. I want to know whether the defendant has a criminal history or not. I want to know if there's a victim involved and how profound the offense might have been and the impact on that victim. I don't want to know, and I never ask, nor do I care, the race of the individual defendant. We don't prosecute people by race, gender, class, socioeconomic group. We prosecute them as we find them as individuals with their own agency and their own responsibility, and I'll continue to do that.
All right, thank you, and I believe there's the last rebuttal flag.
What we need to address is institutional racism, and institutional racism refers to policies and practices of social and political institutions that have disparate and harmful impact on people of color in general and Black people in particular. These practices and policies don't depend on individual conscious prejudice or bias, but rather are driven by unconscious bias and rooted in historical patterns of discrimination.
All right, thank you. That is time. So we're now back to questions for both candidates. I believe we are starting with Ms. Stamos in the responses. So to both of you, what role does the Commonwealth's attorney play in fighting for criminal justice reforms?
Well, I think we can play an important role, and I have played that role. I mean, as I mentioned in my opening, I've been on the front lines of the criminal justice system, instituting progressive programs like the drug court. Before 2011, my predecessor, who was my mentor, didn't support the creation of a drug court. I think it's a valuable tool. I'd like to expand it because I think it's an important thing that we can use to help folks who are high risk, high need get back on track. Second Chance is a reform, progressive thing that we've done to help our youth to avoid suspension and prosecution. And something like Safe Station, which I talked about, is a progressive reform that allows people who are addicted to drugs to make that first step to stop using, avoiding completely arrest and prosecution on the condition that they seek treatment and agree to seek treatment. Those are the kinds of things I've championed, not only in this community, but statewide with the Virginia Association of Commonwealth Attorneys, where I also co-chair the Committee on Justice and Professionalism, which brings all of these issues to the fore among all of our colleagues across the Commonwealth.
That is time. Ms. Tafti.
Well, the Commonwealth's Attorney's Office sets priorities and policies. So they decide what to prosecute and who to prosecute. And in doing that can make all the difference in whether or not people's lives are ruined by a simple marijuana possession conviction and whether they're locked out of receiving educational funding and funding for housing and other governmental programs. They're also responsible for community engagement. How much are they out in the community telling people that they are safe if they report from immigration consequences, and how often are they taking into consideration immigration consequences into charging decisions, and how responsive and accountable are they going to be? There's also the morality pulpit, which is advocating for good evidence-based criminal justice policy. And just a couple of, unfortunately I don't have time to continue, but my opponent took credit for raising the felony larceny threshold, but she actually lobbied against raising it to $1,000.
And that is time. Thank you. So for the next question, this is going to be directed to both of you. It's a two-part question, but I'd also, for the timers, I'd like to give them both 2 minutes to respond. So for both of you, what is one thing within the Commonwealth's Attorney's Office that you think is operating well? And then additionally, what is one aspect of the Commonwealth's Attorney's Office that you would like to improve upon?
Well, I mean, I think that what we do well is we come to work every day to seek justice for the community. And that means justice for a defendant, justice for our victims, and our victims really look to us to be a voice for them in the courtroom. I mean, our office prosecutes thousands of misdemeanor cases a year, several thousand felonies a year. Our lawyers are dedicated public servants who make the criminal justice system work. I would like to see us, as we go further, expand the ability of, this is inside baseball, our colleagues across the bench to have more easier access to discovery. The problem, though, is it's one of resources, and it's one of making sure that our crime victims and witnesses are adequately protected in the discovery process. My office has expanded discovery, and I personally have expanded discovery far beyond what the Virginia Supreme Court rules have called for. And even with the new rules that have been instituted, there's been a pushback. They've been delayed for a year because the Supreme Court has recognized that the resource drain on our offices is going to be profound. So we do that. We do a lot of things well. I mean, anything that individuals are engaging can always be improved upon. I want to continue to serve as Commonwealth's attorney, to continue with these progressive programs, to help our crime victims be able to seek justice in a courtroom and to be vindicated and to be made whole as much as possible.
So since there's a little bit of time, Ms. Stamos, is there a specific policy or program within your office that you would like to see added, or something within the office other than individuals to improve upon?
I'm sorry, I'm specific.
So is there a systematic improvement for the office other than individuals performing more optimally?
Well, I mean, I think I'll go back to the discovery process. I think that is, I know my opponent talks about that a lot. I'd like to see us be more streamlined in it, and I think it's a resource issue. As I said, we do need to have additional resources to make that be more seamless to make the courthouse family more comfortable. And I'd like to work on that in my next term.
Okay, thank you. Ms. Tafti?
Well, the office supports U visas for immigrants who are victims of crime, and I think that that's great. I think that more people need to know about it because the immigrant communities that I've reached out to actually don't know that this is available to them if they are victims of crime or if they cooperate with the police. I also think that my opponent's support for the red flag laws was important and necessary so that people who have protective orders against them, people who are mentally ill, are required to turn in their guns into law enforcement, not simply another family member, but into law enforcement. I think those are important things that my opponent has supported. However, let me just describe for a moment how discovery works in Arlington. Virginia is an outlier in that it does not require even police reports to be turned over. So if you're charged with a crime, you don't get your police reports. Now, in Alexandria and in Fairfax, those offices simply give electronic copies of discovery to the defense attorneys. What this office does is actually a waste of resources, both within the office and on the part of the defense attorneys, because they require a defense attorney to come into the office during business hours and take notes on the files. That is simply a waste of time. The documents should simply be turned over, just like they are in most other jurisdictions around the country, and certainly in our neighboring jurisdictions. Another thing that the office could do better is data collection. There are organizations that, for no charge whatsoever, will come in and collect the data, analyze the data, and make recommendations for how the office could be functioning in a more fair and equitable manner. This has not been done in this office. The office could be seeking assistance from the Bureau of Justice Assistance to create a mental health diversion court. It has not done so.
All right, thank you, and that is time.
Okay.
No, we're out of rebuttals. Sorry.
All right, go
Yes,
ahead. But I thought you
there-
could still use rebuttal.
No. So there were 2 rebuttal flags. That was the unique rules of this debate. So the next question is for both candidates. What is your biggest professional weakness, and where do you have the most room for improvement if elected Commonwealth Attorney? Ms. Stamos, you.
Well, I mean, I think my biggest professional weakness is that the
Yes.
I mean, I think everyone can improve their advocacy skills. I could probably improve, my temper, I suppose. I think sometimes I'm pretty histrionic, and folks who work for me know that I could be very valuable. But I'm very passionate about the work that I do. I love the fact that I can come to work every day simply for the goal of seeking justice. That is a gift that I embrace, and I know the prosecutors in my office embrace it as well. It's a tough, challenging job being a prosecutor. It's important to have tried cases, to understand the mechanics of trial work. It is not a management policy job at all. In most degrees, it's not. It's every day being able to try cases. The craft of prosecution is a craft that I've been honing for 30 years, and I believe that I'm good at it. I believe I reflect the values of this community, and I think it's something that I would continue to want to be able to do to serve this community and reflect the values that you all hold.
That is time. Ms. Tafti.
I think that my greatest weakness is that I need to step away from something. I look at something and I analyze it, and then I need to step away from it, with sort of silence, and I'm not very quick to respond to certain things. And I like to take my time and be methodical and be very, very careful. What I've done in my career is dissected hundreds, if not thousands, of trials. I have the hindsight to be able to look back and see what mistakes the system makes. I understand the science behind all of the causes of wrongful conviction. I am up to date on forensic science and what is junk science and what is not junk science. And I've investigated and taught hundreds of cases and taught hundreds of students how to become lawyers.
Thank you. So we have time for one more question for both candidates. To both of you, what does the term prosecutorial discretion mean to you, and how can a Commonwealth attorney best use such discretion?
I think prosecutorial discretion is a key feature of being a prosecutor. And to my mind, the exercise of prosecutorial discretion does not extend to taking an oath to uphold a law, and then to assuming that the position of Commonwealth attorney and turning around and saying, I'm going to pick and choose the laws that should be enforced. That's what my opponent is saying when she says she's no longer going to prosecute possession of marijuana. To me, that's an entirely anti-democratic position to take, because the General Assembly has determined, and unless they repeal the marijuana laws or decriminalize them, which I support, you take an oath to uphold the law, and prosecutorial discretion, in my book, simply does not extend to picking and choosing among the laws you like and you favor and enforcing those laws, and then choosing not to enforce others. And that's an example of, in my mind, reckless behavior.
Thank you. Ms. Tafti.
Prosecutors are elected by the people that they represent in order so that they can exercise independent judgment and be responsive to the community. I would stop wasting our tax dollars when we're in the position of a budget deficit on simple marijuana possession cases, because those cases don't make us safer, and our juries have telegraphed to us by imposing punishments of things like $1 fines for marijuana possession, that this is not something that we value in Arlington. Moreover, my opponent says that she can't do anything about it because she's required to enforce the law. But there are a lot of laws on the books that we don't enforce. For example, I would like to know when the last time was that my opponent prosecuted adultery, or if my opponent would have prosecuted a sodomy charge against members of the LGBT community before those laws were deemed unconstitutional.
All right, thank you. And so we've now reached the end. So both candidates have 2 minutes for closing. And since Ms. Tafti went first, you go first again.
Thank you again, Arlington Young Dems, and everyone who came out this evening. Debate is necessary and healthy for democracy. And you are by far the most engaged and most informed members of the community by virtue of the fact that you've come out on a spring evening to listen to a debate on criminal justice reform nearly 2 months before a primary. Your work, your votes will shape the future of our community. For 12 years, I've called this community home, along with my husband and our 2 kids who attend public school. Like many of you, I live here by choice, and like many of you, I chose to make this community home because of the values to which it aspires: inclusion, diversity, and fairness. We deserve a criminal justice system that reflects those values. I will work to create a 21st century system that is transparent and accountable, to eliminate cash bail, to expand and create diversion programs for our youth, the mentally ill, those in the groups of addiction, and those with special needs, to identify and fill the gaps in survivor and victim care, and to support restoring voting rights to returning citizens. We can build a system that we are proud of, a system that leads the nation, and a system that reflects our values and keeps us safe without participating in mass incarceration, without criminalizing poverty, without penalizing vulnerable people, without tolerating racial disparities, and without re-traumatizing victims. Reforming the criminal justice system is one of the human rights challenges of our time. It will define the next generation, just as the war on drugs has defined ours. And reform won't happen unless it's done locally, right here. What this campaign has demonstrated is a deep unwillingness to reflect. We're told everything is fine, the office does the right thing, but we can do better, and together we can.
Thank you. You know, Arlington is a public safety success story, and I want to also point out that the jail population in Arlington County is the lowest it's been in more than 5 years. That's not fanciful, that's not a talking point, that's a fact, and it's because of smart policing and smart prosecution. My opponent talked about, for instance, discovery. She wants to be able to turn over to a defense counsel who represents a domestic abuser the handwritten statement of a crime victim that purports to tell the story of how, the anguish and the hell that she takes on at the hands of her abuser. And she wants the Commonwealth to turn over that written statement to the defense attorney and making that written statement a product of the defendant, who then the next time he gets to whack her around a little bit, he pulls out a copy of that written statement that she hand wrote 6 months ago to wave in her face and to continue the beating. These are concerns that I have as the elected Commonwealth's attorney, protecting victims and witnesses to crime. My opponent mentioned earlier that the jail never did anything for folks who are addicted to drugs. That's because she's unaware of how the system works in Arlington County. The ACT unit is a very vibrant and robust in-jail drug treatment program. I urge you to come to one of the ACT unit graduations to see the services that the jail provides under the auspices of Sheriff Arthur in making a drug addict's life get on a good track. And as far as U visas go, I'm so happy, and I celebrate the days that I can sign a U visa for a victim who is undocumented, who comes forward, steps up, and decides to look her abuser in the eye and see a prosecution through. But a U visa is not something that we can proselytize in the community, because it's defense counsel who turns that into a sword and makes it something that can cause a woman to fabricate a domestic violence claim just so she can get a U visa. So you have to be very careful about that. The comments my colleague made tonight, my opponent and my colleague, show a deep misunderstanding of trial work, of the role of a prosecutor, and what it means to be a Commonwealth's attorney. Thank you.
And thank both of you for a very spirited debate. And once again, I'd like to thank all of you for coming here and listening to the debate tonight. I'm going to turn this back over to the AYD leadership, Mr. McBurney.
Let's give it up for Maggie Davis for great moderation and to the candidates for a great debate.